Hello, and welcome to the Florida Bar's Henry Latimer Center for Professionalism CLE seminar, Know Your Worth, How to Professionally Negotiate Salary and Benefits and Bridge the Gender Pay Gap. My name is Magdalena Ozarowski. I currently serve as the chair for the Gender Bias Working Group of the Florida Bar Standing Committee on Professionalism. By way of background, the gender pay gap is defined as the difference between women's and men's average weekly full-time equivalent earnings, expressed as a percentage of men's earnings. It exists in all industries, though the disparities may vary. It was first brought to popular attention in the United States in 1963, when President John F. Kennedy signed the Equal Pay Act. And to a certain extent, the act worked. It raised a woman's average earnings from 62% of a man's to almost 80% by 2004. In the legal profession, the ABA's 2019 A Current Glance at Women in the Law publication found that overall, women lawyers' weekly salary was 80% that of men's in 2018, and male equity partners were paid 27% more than female equity partners. And the fact is, men continue to dominate the higher paying and higher ranking legal jobs. Another recent study found that though women on average bill more time than men do each day, women are billed at lower rates than men, sometimes significantly lower. There are various explanations and data points for this disparity. Some are better supported by the data and some are still conjecture. In this CLE, we will only be talking about one: the fact that women are less likely to actually negotiate for their salaries. In short, and to steal the title of a very comprehensive book on this subject, women don't ask. We are hoping to change that. We have an illustrious panel for you with 4 women who are truly experts in their field. All these presentations were filmed virtually due to pandemic considerations. First up, Florida Bar Board Certified Labor and Employment Attorney Patricia Sigmund will provide a primer on the Equal Pay Act, Title VII, and the legal parameters and protections regarding equal pay. Then, Professor Aaron Ryan from FSU School of Law will talk about how to approach salary negotiations, as well as providing some insight regarding the underlying stereotypes and pressures that dissuade women from negotiating for their salaries and benefits, essentially answering the question why women don't ask. Kimberly Sands, a professional mediator, will talk about both skills for successful negotiating as well as avoiding common pitfalls. And finally, Tiffany Henson, a lawyer and a legal recruiter, will talk about her experiences in negotiating salaries on behalf of women and what you can learn from that. Thank you for joining us today. Our first presenter, Patricia Sigmund, is a Florida Bar Board Certified Labor and Employment Lawyer and Florida Supreme Court Certified Mediator. She's been practicing employment law in Seminole County for 28 years, representing primarily individual employees in her law firm, Sigmund & Sigmund. Ms. Sigmund is also a current member of the Florida Bar Labor and Employment Law Certification Committee. She received her BA in English from the University of California at Los Angeles, UCLA, in 1989, magna cum laude, Phi Beta Kappa, and then graduated ranked number 1 in her graduating class from Stetson University College of Law, summa cum laude. Welcome, Patricia Sigmund.
Thank you. I'm excited to have the opportunity today to talk with you about pay discrimination. We have many topics that we can talk about with regard to sex discrimination, but today we're focusing just on sex discrimination with regard to pay and the situations that lawyers may find themselves in as employees having pay disparities and what they can do about that. So let's get started. The first law I want to make sure people are aware of is the Equal Pay Act of 1963. It is a federal law, and it prohibits sex-based discrimination in compensation. And compensation isn't only the salary that you earn, but it also is bonuses and reimbursements and all of the financial benefits and things that you get by way of monetary compensation in your employment. So it requires that men and women be paid equal pay for equal work, which sounds very simple. And if 2 people are doing exactly the same job, standing next to each other at exactly the same workplace, it's a relatively simple thing to figure out because you have 2 people doing the same job. And if the man is being paid more than the woman, then the woman under the Equal Pay Act has to have her pay raised in order to meet the same pay as the man is making. Nowadays, though, many of our jobs are much more nuanced, and many of us aren't doing exactly the same job as the person next to us. And so even lawyers in the same firm may be practicing in different practice areas. Those different practice areas may have different revenue related to them. And then we get into the more nuanced issue of what is equal work, what is comparable work, that you have to compare a man and a woman as to whether they are in fact in compliance with the Equal Pay Act. So it's work that requires substantially the same skills, effort, responsibilities, and working conditions. And it does have to be in the same establishment. So if a person has a law firm that has an office in Florida and one in California, we don't compare the wages in Florida for a starting lawyer to the wage in California for a starting lawyer, for example. We're talking about the same establishment, which generally means the same actual physical workplace. It can be a little bit different with regard to virtual employment, where we have people working virtually right now. But for the basics of it, we're talking about the same establishment. You cannot raise the man's you cannot decrease the man's pay in order to meet the woman's pay. So there's no jeopardy that if you complain that you are making less than your male peer, that he will have his pay decreased. The pay actually gets brought up, which is a good feature of this law. But the real key to this particular law is that you don't have to show discriminatory intent. So you don't have to show that your employer purposely wanted to pay you less because you're a woman. We're going to take a look at a moment in Title VII, which works differently than that. But for the Equal Pay Law, there really is no requirement of intent on the basis of sex to discriminate. And that makes it something that's often easier to talk about with the employer. And there are affirmative defenses available to the employer if there are bona fide non-discriminatory reasons, such as a seniority system that results in the pay difference. So if you've got a woman who is making less than a man who started 3 years before her, but when he started at the same place she started, then a bona fide seniority system is usually going to be compliant with the Equal Pay Act. And we do have a coverage scope for the Equal Pay Act, which is the same employees that are covered by the Fair Labor Standards Act. We're generally talking about employers who are in categories of $500,000 a year gross revenue. But we do have a Florida statute that covers employers that are smaller, that don't have that much revenue, all the way down to an employer who only has 2 employees. So the Florida statute that is the equivalent of the Equal Pay Act is 448.07. And so even if you only have a 2-person firm that's bringing in $100,000 or $200,000 a year and doesn't qualify for the Equal Pay Act, you still have coverage in Florida. So let's compare that to Title VII of the Civil Rights Act of 1964. The biggest difference is that the Title VII law does cover more than the Equal Pay Act. It doesn't only cover pay, it covers all the terms and conditions of employment, all of the way that people are meted out their work and the scope of responsibility that they're given, and all of the conditions of working in a place, what rules are applied to people, what they're allowed to do, what they're not allowed to do. It's not allowed to be discriminatory on the basis of sex. And of course, the Civil Rights Act covers more things, more categories than sex, but today we're focused just on the sex discrimination piece. And so when it comes to equal pay under the Title VII of the Civil Rights Act, the biggest difference is that you do have to show intent to discriminate on the basis of sex. And so that covers employers that have at least 15 or more employees. We also have a Florida Civil Rights Act that works just like Title VII. It covers sex discrimination for employers that have at least 15 employees. And there are pre-suit requirements like going to the EEOC before you can sue on the Civil Rights Act of 1964, whereas under the Equal Pay Act, you don't have to do that. You can go straight to court. So you've got an additional opportunity if you have an employer who's smaller than 15 employees. There is no state law that gives protection against sex discrimination like this for smaller employers, but we do have the local ordinances, and many of the major large counties in Florida and some of the municipalities actually have ordinances. So, for example, Orange County, Florida is one I'm familiar with, and it has an ordinance that covers employers as small as 5 employees against sex discrimination in employment. So an employer could be violating both Title VII and the Equal Pay Act, and or it could be an issue that is really only covered by one or the other. But the attractiveness of talking about the Equal Pay Act, if you're going to talk with your employer about equal pay, is that you're not necessarily having to accuse the employer of intentionally discriminating against you because you're a woman, because the Equal Pay Act doesn't concern itself with that issue. So the main issue or problem or obstacle that a lot of people run into when they are concerned about equal pay is retaliation. What is my employer going to do to me if I raise my concern that I'm not being paid the same as my male peer who's sitting 2 offices down and doing the same legal work that I'm doing day to day? So it's important to understand the anti-retaliation pieces of these statutes and how they work. Title VII does prohibit retaliation against an employee who opposes a violation of Title VII or who participates in the EEOC process in regard to a violation of Title VII. The Equal Pay Act itself prohibits retaliation for employees who oppose equal pay violations. The Florida Civil Rights Act also prohibits retaliation in the same way Title VII does. It covers the same things as Title VII. The local ordinances that I have seen, Miami-Dade has one, for example. As I said, Orange County, many of them. They also include anti-retaliation features. And then we have a really broad whistleblower statute in Florida, which is Section 448.101 to 105 of the Florida statutes, that isn't limited to discrimination cases. It protects against retaliation for any employee who has 10 or more employees in the employer company and that objects to or refuses to participate in a violation of law, rule, or regulation. So when you're objecting to discrimination on the basis of pay, you have lots of coverage for retaliation that would happen in the employment. But if you look at the very last bullet point on this slide, the real key to making sure that you protect yourself against retaliation is to make a clear and written complaint as a strategy. Because what happens is people want to have a conversation maybe with their boss about these concerns, but they're afraid to put something formal in writing. And then when they get retaliated against, their employer may deny that conversation with the objection about discrimination even occurred. Or they may have just heard it differently. They may have not understood that what the person was saying was discrimination. So I know that it sounds like a really big step. And for a lot of people, it's a very intimidating and scary step to put something in writing to their employer, like an email, and say, hey, I'm concerned that my pay or the pay of my coworker, it doesn't appear to be equal and equitable compared to, her male peer or peers. But it's the only way to do it and protect yourself as a practical matter against the retaliation. Because if the retaliation comes and you can't prove that you ever made the underlying complaint, that's the protected activity, you can't make a discrimination claim for the retaliation piece. So it is something that you really need to kind of come to the decision that you're going to make that objection, and then just do it in a professional, appropriate way. And most of the time, the employer will do what it needs to do or give you the justification for why they don't think that they should have to. And sometimes they may have a reasonable defense or basis that you didn't know. So those are the basics of the statutes that we're going to talk about. And what we want to do is do some question and answer to kind of put that into practice and get away from just the dry recitation of the law and see how it actually works with scenarios for women who are lawyers. And I've represented many lawyers over the years in their various employment discrimination concerns, and obviously it's a unique type of a role that we have. So let's talk about some of the questions that you have.
Thank you, Patricia. Let me ask you, how will a woman know if her employer is paying her male peer more than her?
She may not. And that is a problem. Figuring out whether you are paid less than your male peers or peer is often something that women don't do. It's often something they have no idea about. It is a combination of some employers have essentially a policy or an unwritten rule or code about not talking about your wages, and we'll talk about that in a moment. But also, people sometimes find it just unseemly or tacky to talk about their pay with other people, and that has that combination of factors and just kind of the social mores of it have made it so that a lot of times women will be working for many years in a workplace and have absolutely no idea that the guy sitting next to them in the next office is making more money. Often I have found that people find this out by accident, because someone will send them an email that wasn't intended for them, or leave something on the copier that's a copy of their pay stub that they were shocked to see, or someone gets the wrong paycheck when they're delivered, or someone just mentions something and it stirs up a question. So I have met many women who found out quite by chance that they were making less than their male peers. And I can tell you, it's a devastating feeling, because it presents a feeling of not being valued as much and not being as valuable and not being as worthy. So, but I think that it's important for people to ask. And when you're in a non-management position, when you are a rank and file employee, you are covered by the same basic National Labor Relations Act requirements, that an employer can't have a rule that just prevents every rank and file employee from talking about their wages. And so that concept is important for people to understand, and it's important for people to be willing to ask. And I think that sometimes just being direct about it and going to your human resources professional, or going to your peer, or going to your boss and saying, hey, I've heard that a lot of times people don't necessarily know what their peers are making, and therefore sometimes they don't realize they're not being paid equitably related to their peers. I'd really like to know, what my peers are making. Are we making the same thing? And that may stir up a conversation. So it depends upon your workplace. If you are in the public sector, then Public Records Act requests are perfect. And Florida has a really broad Public Records Act. I have had many women who are in the public sector who we've been able to do public records requests and just get the salary records for everybody in the office, and then you have all the information. It is much easier in the public sector.
So, what should a woman do when she learns a male peer is being paid more than her?
I think that the first thing she needs to do is ask herself, is this comparable work, right? Is there any obvious differentiation factor between the skills and the responsibility level and the work that she is doing as compared to that male peer? And try to anticipate, well, what would the employer identify as the differentiating factor, right? Has he been there longer? Does he have a larger number of clients based upon the way that the firm was structured before she ever even got there? Things like that. And then I think those things you want to anticipate, not that they are, depending on what they are, not that they are necessarily fatal to a claim, but they are important to anticipate, because when you get into that discussion, you don't want to be unprepared. And then I think that the important thing then is to, in writing, once you feel like you're correct, that this is comparable work, that you put in writing to your boss or to HR or both. And I would encourage you to include whatever decision maker would have the opportunity to make a decision to terminate you, because that way you make sure that they're on notice of this complaint in a visible way. But you can send an email and say, hey, it's come to my attention that this person may be making more than me for comparable work, and I'm concerned about that, and I'd like to have a discussion about it. When can we talk? And open up that dialogue. And I think that many times employers are unaware or didn't really do the comparison. They haven't had somebody really taking a side-by-side look at things. And especially if you've got people who are lateral hires. I mean, if you have two people who were hired and started on the same day, chances are somebody took a look at what they were paying relative to each other. But, we don't have to assume that every time this happens, it was intentional. Sometimes it's just sloppy. Sometimes it's failure to kind of go back and review. You start hiring in a lot of lateral hires, and now you're not going back and reviewing what the people that are already in your firm who have comparable level of experience and skill and work are getting paid. And all of a sudden you've got this disparity, and it's the employer's obligation to, be taking a look at that all the time. So I think you can approach the conversation from the standpoint, this may not have been anything anybody did on purpose, but we just need to make it right. And we need to not decrease his pay. We need to increase mine to make it the same. And, it is when you get into questions of what the employer is saying, well, you don't take on the same, number of clients that this person does. Well, that may get into some Title VII issues, because at that point, the woman may be concerned that she would have liked to, but each time she's asking to go to this next type of opportunity or place where she could grow her client base or her career, maybe she's not being allowed those same opportunities and the same latitude as her male peer. So because of that, it's important that's why I brought up in the beginning of this talk, the Title VII piece as well, because sometimes you have to get into a conversation about, well, why is it that my male peer who's got the same degree as I do and the same the same bar license I have is making more than me? Is it because he's had more opportunities that I'm not getting? And what can we do to make sure that I am getting those same opportunities like Title VII would allow? And, it is a skill that you have to engage in, both, smart conversation, but also be a good advocate for yourself. You don't want to come right out and say, well, I know that, you're violating this law on purpose. Let's just get it worked out. Right.
Can you talk about, in your experience, what mistakes people make in addressing wage discrimination?
I think that one of the mistakes people make is not putting their complaint in writing. I see this repeatedly. I see people who come in, they've been fired, or they feel like they're about to be fired, or they just got a horrendous review and they don't understand why the employer has done this to them, and they feel it's retaliatory because they had brought up this pay equity issue, and it either got resolved or didn't get resolved, but now the employer is retaliating, and they didn't put it in writing. So when we contact the employer, they say, we never got that complaint, or we don't remember that, or nobody's heard that. So I think that's an important problem. I think the other thing is that people, they will know about it, but they will learn about it and just be literally afraid to say anything. And I think that the problem with that is it's not sustainable, because the resentment grows and it ends up showing in your work. And, it's not a sustainable long-term process to be working for an employer who is paying you less than their male peer who you believe is doing exactly the same work. And frankly, when you get into the conversation, you might find out there is something that person has done or has accomplished that you didn't realize, or that they have, negotiated some opportunity for themselves, that they went in and advocated that they wanted to do an extra job on top of the regular job. And that's how they're making that extra piece. And that's when you come in and say, well, I want that opportunity as well. And then you use the Title VII, broader protections to make sure you're getting the same opportunity. But I think that fear and the paralysis of fear is what causes people to really be afraid to document it or afraid to bring it up. And the problem is the statute of limitations, the standard statute of limitations on the Equal Pay Act is 2 years from each paycheck. So if you work for a place for 5 years and you don't bother to complain until, the very end, you have lost some of your equal wages out the back door because you waited too long. So you want to raise that issue and make sure that you're bringing it forward.
And are there any issues that arise for in-house counsel in dealing with her own wage discrimination issues?
Yes, and it's very tricky. Our friends in the ethics department of the Florida Bar can probably provide additional insight on this. But my feeling is when you're in-house counsel, the company is your client. And if you feel like you are being subjected to discrimination and you make a complaint that doesn't get resolved, and now you want to file a claim, you are now in a claim against your own client. And I'm not an expert on the nuances of the ethics issue, but it is a very difficult spot for in-house counsel to be in when they feel that is happening. I think that it is appropriate for in-house counsel to certainly bring the concern to their superiors and raise the issue and say, hey, I'm in-house counsel and this man sitting next to me was started at the same time and we do the same job. And I just figured out he's making $10,000 more a year than me. And I'm asking you, please, under the Equal Pay Act, to equalize that pay. And, don't take my word for it because I'm normally your lawyer on these things. Go get other counsel and get yourself independent counsel and have them check it out. And let's work this out and continue our positive relationship. I think that when the relationship breaks down further, then in-house counsel gets into a point where they've got to really assess what their ethical obligations are in that kind of a dispute with their employer. But it's tricky.
So I'd like to get your insight on a more general issue, which is that in light of the Equal Pay Act, which seems to be rather broadly encompassing of the subject at hand and was passed almost 60 years ago, why is there still a gender pay disparity?
It's a great question. And a lot of it, I think, comes down to something we talked about a little earlier, which is a lot of times women don't know that they're being paid less than their male peers for the same work. Lilly Ledbetter is a perfect example of that. What happened with Lilly Ledbetter is she was working for that employer for many years. And, now her name is famous because of the Lilly Ledbetter Pay Act and all of the publicity that went around that case. But she did not know for a long, long time. And when she found out that she was being paid less than her male peers, it was already many years after the employer had made the discriminatory pay decision that had resulted in her being paid less. And so that's why she got into a statute of limitations problem under Title VII. And that led to the legislation that was changed. But it's just a common problem. I can't even tell you, every year I see, multiple women who have just figured out through some serendipity or some accident or some moment that wasn't even planned, that they're being paid less and they're kind of shocked. So I think that's just what it is. I think a lot of people, they don't ask and they just assume that, hey, we're doing the same job, we're getting the same pay. And that's just continuing to go on due to lack of knowledge, lack of information. And I think also just people being timid about talking about money because it's often an uncomfortable thing to talk about for people. So all of those things together, and then lack of people feeling empowered to enforce these rules or going to their employer and explaining their concern and having the employer give them an explanation that maybe doesn't satisfy the requirements of an affirmative defense under the Equal Pay Act, but the employee kind of doesn't want to push it further, so they just live with it. There's a lot of human factors in why we have, still this very large, very documented gender pay gap.
So finally, when we talk about women in the workplace, that doesn't only mean cisgendered women. It can and does include trans women. So do the protections of the Equal Pay Act apply and protect trans women as well?
Sure. So I haven't seen a case on the Equal Pay Act specifically, but just in the past year, we certainly saw a big decision out of the U.S. Supreme Court with regard to sex discrimination and what that means under Title VII. And I think it's reasonable to believe that the same will apply to the Equal Pay Act, which is that because of sex means regardless of whether it's being male, female, whether your sexual orientation or your gender identity is non-binary. So I think that the same will apply. And I think that certainly if an employer was paying a trans woman less than her male peers, that I think a good argument would be made that the same rules apply under the Equal Pay Act. And if not, then certainly under Title VII, the protection is there that, it is all because of sex. And the idea of these laws was that people weren't supposed to be discriminated against in their employment because of sex. And, a long time ago, Ruth Bader Ginsburg kind of taught the court what all that meant, right? And that sex discrimination exists and what it looks like. And in the past years, we've seen the LGBTQ community kind of teaching the courts and their lawyers teaching the courts what it looks like with regard to LGBTQ rights and what that kind of sex discrimination looks like. So I think that given the court's decision last year, that we can expect that it would apply across the board.
Thank you so much for your time, Patricia. It is very appreciated.
Thank you. It was great. I appreciate it.
Our next presenter is Professor Erin Ryan. Professor Ryan is the Associate Dean for Environmental Programs and the Elizabeth C. and Clyde W. Atkinson Professor of Law at Florida State University, where she teaches environmental and natural resources law, property and land use, water law, federalism, and negotiation. She has presented widely in the United States, Europe, and Asia, including at the Ninth Circuit Judicial Conference, the National Association of Attorneys General, the United States Forest Service, and the United Nations Institute for Training and Research. Professor Ryan is a graduate of Harvard Law School, where she was an editor of the Harvard Law Review and a Hewlett Fellow at the Harvard Negotiation Research Project. She clerked for Judge James R. Browning of the U.S. Court of Appeals for the Ninth Circuit before practicing environmental, land use, and local government law in San Francisco. She joined the FSU law faculty in 2015. Welcome, Professor Ryan.
Well, thank you, Maggie, and to the bar for inviting me to be part of this important conversation about gender bias in employment negotiations. This is a subject that I talk about with my negotiation students every year, and it definitely bears talking about long after we have left law school. So I'm just going to set my presentation up. Here we are. And let me tell you a little bit about what I'm going to cover today. I am going to start by answering the question, as soon as I can move my slide, answering the question that was asked, how should women negotiate employment terms? And in fact, I'll give a quick nutshell on how anyone should negotiate employment terms. Just a few bullet points to help folks who are doing this maybe for the first time. But then I'll talk about why it is that women, or at least some women, struggle with employment negotiations, leading in part to the gender gap that we see in salaries. I'll address the phenomenon in which women are less comfortable pressing for their own advantage, and also the recent research shedding light on why that is, which is that women are essentially accurately predicting the backlash that they may receive because of gender bias. Then I will cover the professional advice that negotiation professionals are giving to women in this situation, but I'll address the cognitive dissonance that it leaves with me about advising women to navigate around gender bias without really resolving the ethical underlying problem of gender bias. I will finish up with some thoughts about how to move forward personally in a way that perhaps feels at least more comfortable for me, and also how we can move forward as a profession to eliminate gender bias so that women don't have to navigate around it. And towards the end of the presentation, I'll also give a little bit more negotiation training, some specific negotiation skill building to help women, and indeed all section members, all members of the organization in that situation. So let me start, as promised, with a little primer on negotiating salary and employment terms. I begin with the same advice I would give anyone negotiating for anything, which is that you begin by preparing carefully and doing your research. In fact, I'll give a little training at the end of the talk today about how to prepare for negotiation. One thing we know about what separates successful negotiators from the rest is that successful negotiators are disciplined and diligent in preparing before they sit down at the table. You want to know what it is that you want, and also what it is you want to ask them before you begin, ideally before you sign on the dotted line, at a minimum. So after thinking about what it is you're hoping to get, you want to be able to persuade them why your ask is reasonable. And you can do that with objective criteria. So part of your research before the negotiation, part of the preparation, is learning as much as you can about the industry standards, about salary and employment terms for others in like positions, others in the region, others in the industry, maybe the firm policy on such matters. Have as much information as you can and ground your ask in these objective criteria. You can also use objective criteria to scrutinize their offer. Make sure that their offer is based on objective criteria. Making sure that it's based on objective criteria is a very good way of undermining gender bias by making sure that figures are connected to qualifications and nothing more. So you can, for example, use this advice to query their offer. Tell me more about your salary structure. Can you help me understand what it is that makes this a fair offer? And if those questions seem uncomfortable to you, stay tuned. It may be that you see yourself reflected in some of the research that I will address. As always, you want to look for opportunities to bridge the interests on both sides of the table. You will face some factors in a negotiation over employment that are perhaps we would say zero-sum factors, meaning everything that you get is something they lose. Everything they lose is something you get. Salary is a good example of that. All things considered, you would like to be paid more. They might like to pay you less in order to do other things with that money. But those zero-sum factors can always be partnered with other factors where your interests may overlap more. For example, developing your expertise is something that benefits you, but it also benefits the organization. There may be opportunities to create value beyond salary terms if both of you value flexible scheduling, working from home. Since the pandemic is something that can benefit both the employer and the employee, there may be room to trade on benefits. To some salary factors, maybe if you cannot get the salary you want, you might be able instead to get flexibility or benefits that you want. Keep in mind as you go that you are negotiating a working relationship that, if things go well, will be a working relationship that you are working in for a long time. So always be mindful of setting the tenor of the kind of a working relationship that you want to have. But most importantly, another thing that distinguishes successful negotiators from the rest is the importance of setting high expectations. You want to go in, having done your research, with an ambitious but reasonable, one that you can justify, but a high expectation, an ambitious expectation of what you want, and you want to aim for that, and not the bottom line. Again, what the distinguishing feature of good negotiators is that they aim high and don't just play it safe. Now, the reason I want to finish on that point is because that point bridges to one of the hurdles for women in the salary and in the employment negotiation context. It has been noted, for example, in the Linda Babcock 2003 book, Women Don't Ask, that one of the problems that seems to hobble women in employment negotiations is that they feel uncomfortable advocating for themselves, and in employment contexts, tend not to do it as forcefully as their male counterparts. We know that women negotiate just as effectively as men, especially in law, where there's lots of data to show this. They negotiate just as effectively as men in other contexts. They both set similarly high expectations. They achieve similar results on behalf of their clients. The only place where we really see the difference is when women are negotiating on behalf of their own interests, especially with regard to salary, and especially early in their career. And this is important because the salary at the beginning of your career, being able to ask and advocate for a salary at the beginning of the career can ricochet all the way down the line, because raises follow that initial salary. Lateral moves follow a salary history. So training women, making it possible for women to ask at the beginning of their career is a really important rate determining step in many employment contexts. And it's estimated that as much as a substantial part of the 80% wage gap that we see by gender, in which women, college educated women on average earn maybe about 80 cents on the dollar compared to their male counterparts, a substantial percentage of that may be traceable simply to this phenomenon, the phenomenon in which women don't ask because they don't feel comfortable advocating forcefully on their own behalf, even when they have the skills to do it. Now, before I say more, let me pause and acknowledge that this is a stereotype. Not all women fit this generalization. Many women are comfortable negotiating on behalf of themselves, advocating on behalf of themselves, and there are many men who are uncomfortable advocating on their own behalf, and they fit this stereotype that I'm associating with women. And let me pause here to acknowledge that these are also gender binary stereotypes in a world where we increasingly recognize is not a gender binary world. So I am trafficking in the stereotypes that lead to this gender bias, recognizing that not everyone will fit, even within the gender binary vocabulary. Whatever your gender is, if the stereotype that I'm describing of feeling uncomfortable advocating for yourself, if that fits you, if that feels like you, we do have some general advice that I, for example, give my students of all genders in this scenario. And that advice is to create a constituency for yourself so that you are not simply advocating on behalf of yourself. You're advocating on behalf of your constituency. So, for example, if you want to reframe the negotiation as something you're doing on behalf of someone else. If it's a salary negotiation, for example, envision yourself as negotiating on behalf of your family, who will benefit from that salary. If it's for recognition, negotiate on behalf of your team or your proud parents or whoever it is that is invested in your success. And this is good general advice to try to help overcome the hesitancy to negotiate on behalf of your own interests. But it isn't enough. And so we see this problem continuing to plague women, so much so that Sheryl Sandberg made a great contribution in 2013 with her Lean In manifesto, really an impetus for change, trying to encourage women to do more and asking to do more and advocating for themselves. And her book became an impetus for change, especially among professional women whose experiences most closely matched her own. But even in this manifesto, trying to encourage women to be more assertive, Sandberg notes that women may need to combine this insistence, this advocacy, with niceness, which leads to the next part of our conversation, which is some troubling research that has been revealed in the last 6 or 7 years, helping us understand exactly why it is that women don't ask. And so this research in the last 6 to 7 years is following some studies that have come out to show that to some extent, the reason women don't ask is because they are correctly predicting the backlash that they will face in light of gender stereotypes that punish women for being too assertive, for not conforming to the gender stereotype associated with women, which is to advocate on behalf of others, to be other-focused as opposed to self-focused. And so, for example, Kieran Snyder writes in a famous article in 2014 in Fortune magazine about what she calls the abrasiveness trap, based on research of hundreds of performance reviews in the technology field, in which she shows exactly this problem. Women are punished when they ask. Women who advocate for themselves are seen as less likable. They are described with words like abrasive and shrill, to be two classics. And this is in comparison to men who, when exhibiting the same behaviors in the employment context, are seen as strong, decisive, assertive leaders. So when women when women exhibit these same behaviors, they're punished as abrasive. When men exhibit them, they are rewarded as leader-like. And it sets up this double bind that women face between competence and likability. And so in this problem, women can be seen as either competent or likable, but not both. And competence follows many of the behaviors or the characteristics that have been in this gender stereotype world associated with masculine traits, assertion, maybe even assertion, decisiveness. So when women adopt those behaviors, the behaviors that are necessary to prove their competence, they can provoke negative judgments about their likability. And it turns out that for women, being likable is very important, even in the professional sphere. And being seen as unlikable, difficult to work with, can have significant career impacts down the road. So unfortunately, in the last several years, we've seen some exhaustive research from a variety of sources the Snyder technology study that I mentioned, McKinsey, Visior have all done studies in the last several years revealing gender bias along the competence versus likability double bind in every field, from Fortune 500 companies to technology, to law, to academia, to government, to industry. And very troubling, this gender bias comes from women as well as men. Women are just as likely to punish other women for exhibiting these behaviors. The very same behaviors that are necessary for them to be competent in their job are punished with personality judgments. It's quite distressing that in some of this research, which studies performance reviews and compares performance reviews for high achieving men and women in the same fields, what it shows persistently is that women's performance reviews are replete with references to their personality, and often negative references that are absent from the performance reviews of men, highlighting that women's engagement with these skills for the workplace are associated with a dislikable personality. And this leaves women with this excruciating cost-benefit analysis in which the long-term costs of advocating for themselves, violating the gender norm that associates women with caring for others, but not themselves, the long-term costs of advocating for themselves can outweigh the long-term benefits over the course of a career. So that when women don't ask, they're not acting irrationally. Sadly, they may be acting exactly the opposite, as they may be acting rational. This is a rational cost-benefit analysis. This distressing data led to a plethora of professional advice from negotiating experts, advising women how to cope with this information. Now that it's not just our fear, now that we know that women really do get punished for asserting themselves in these environments, what can they do? And so there's been a cottage industry of coping skills, and I'm going to share with you some of what this industry provides. I will flag that I find it distressing, but I'm going to share it with you so you know what the advice is. Some of that advice goes along these lines. Adopt 2 goals for the negotiation. When you're negotiating in an employment context, if you're a woman, compensation is your first goal, but just as important is leaving a positive impression with your employers and coworkers. You want to get the salary that you deserve, but you must do it with paying very careful attention to maintaining the relationships and the positive impression that they have of you as someone that they want to work with, and that has to be part of the equation, or else you face backlash. Another associated piece of advice is to provide a relational account for your ask. Frame your request not just in terms of yourself, but in terms of others' welfare. Emphasize why providing you with the raise that you're seeking will benefit the organization. It will benefit the team. It will benefit others there. It will benefit the public facing front of the organization. It will benefit the community in a wider way. And this is to disassociate a woman advocating for herself from the negative stereotypes associated with self-promotion. One law professor, Joan Williams at UC Hastings in 2014, wrote for the Washington Post about the phenomenon she calls gender judo, in which after interviewing many, many high-achieving women, she heard a refrain that she refers to as gender judo, in which women describe using feminine stereotypes that make other people feel more comfortable to propel themselves forward and kind of help them over the edge of when they have to transgress those gender stereotypes. So comfortable female gender stereotypes include things like the selfless mother, the dutiful daughter, the good-natured big sister, and that many of the women she interviewed, high-achieving women in their fields, learned to use those stereotypes and conduct themselves mostly in accordance with those stereotypes in order to cushion the need for them to act assertively and violate those stereotypes when it was really necessary to be done. She calls this, and she advocates for women to use gender judo in order to advance themselves despite this bias. Now, this is the advice that professional experts began giving immediately after this data was revealed by academic studies showing the pervasiveness of gender bias and negative judgments of women who advocate for themselves. And yet I have to tell you how upsetting I find that research, as do many of my students, as will some of you, perhaps many of you. It's upsetting because it's essentially asking women to conduct themselves differently from their male counterparts in order to account for and take care of other people's bias. It's asking women to bear a higher burden in terms of protecting their impression as well as seeking their salary when men don't have to. It's asking women, some women, to adopt a persona that may not be true to themselves in order to make others feel more comfortable and avoid the backlash of gender bias. And that feels terrible to me. I don't ever want to ask my men and women, my male and female students, and all my non-binary, gender non-conforming students for whom this is only that much more pronounced, to try to be someone they're not in order to cope with other people's bias. It feels terrible. And so what I do when I teach this material is I am pretty transparent about exactly this. First, I share the content because I think they need to know. It's not in our imagination. Gender bias is out there. Working around it is important for women who want to advance even in the face of gender bias. But I don't love telling people to be someone that they're not. So I give them this information and invite them to make their own decision about what they want to do with it. And so for some women, for some people, this will be easier and more natural. And for others, it will be more difficult. And it is possible to make the decision that being true to yourself rather than conforming to gender bias is the right decision, even if there are costs associated with that decision. So my mission is only to give you some information about what those costs are, but to empower you who are making decisions for yourself to consult your own interests and know what it is that's more important. In addition to that, I would like to give you some useful advice that feels slightly less terrible to me. So let me move forward in my talk to share some thoughts about how we can move forward in this gender biased world, both personally and then a little bit at the end of my talk as a profession. So some advice that I can offer for us to work with as individuals in the face of gender bias, and advice that I feel good about giving to all of my students, starts with something really simple, and that is negotiation skill building. And this is advice for men, women, and everyone who doesn't conform to one of those categories. Improving your negotiation skills are the best way of threading the needle that we all have to thread in the workplace between managing both the competence requirements of our work and the relationship requirements of our work. So in gender bias, the competence likability problem is, we frame it as a problem, but really competence is about skills and likability is about relationships. So I would like to reframe it this way. Negotiation training helps you get better at the skill part of what you do, which leads to your competence. But every negotiation is also about managing relationships. And it doesn't always mean being liked, but managing relationships is a skill that's important for men, women, and everyone to master. So I'm going to give a little bit of negotiation skill training in just a moment to leave you with something concrete. But I also want to mention the value of building community and professional support networks in the face of gender bias. Building strong relationships after taking the job is an important way of protecting yourself from backlash, but building strong relationships before you take the job is also an important way of advancing your interests in securing favorable employment terms. If you can form a positive relationship and earn the respect of the hiring partner or the managing partner, you can enlist them to advocate for you in the employment negotiation. In addition, you can build professional support networks once you're in the job to consciously promote one another to avoid the backlash of self-promotion. So, for example, Erin could send an email out to the organization telling them about Maggie's fantastic recognition, her professional accomplishment and how it was recognized. And that gets Maggie all the credit she needs without inviting the backlash of self-promotion. And Maggie can do the same thing for Erin. And so can Joseph and Stephen. So this is not something that only women can do for each other. This is something that professional communities can do for each other. Number 3, emphasizing your role in the team is good advice for everybody. You can avoid gender bias backlash, and you can also just build a good team by emphasizing your value to the overall organization. When you are advocating for yourself, you are advocating for yourself on the way into an organization that you will then use the same skills to advocate on behalf of. Whatever you're bringing to the table at the employment negotiation is something that will then be on the table for the organization going forward. And a famous example of this is what Sheryl Sandberg said to Mark Zuckerberg in the negotiation that she had to take her job at Facebook. after rejecting an employment offer for a salary that she would have accepted because it seemed fine to her, but it was pointed out by her husband was very low in comparison to male counterparts. She went back to the table, and to help bridge the discomfort of advocating for more, she pointed out this was the last time they would be on opposite sides of the table. Everything she was bringing to the table in support of herself would soon become in support of the team, and it was effective. And finally, if this is not the theme of the presentation today, increase objectivity. Use objective criteria when negotiating the terms that you want, and insist on objective criteria, both in defending the offer you take and in the performance measures that may be applied to you in the future. And when you become the assessor, use objective performance criteria in evaluating those that you are reviewing. By using objective criteria and tying compensation and reward and recognition to objective criteria, this is our best weapon against bias, because it takes the negative personality factors off the table and just links reward with concrete, unbiased, objective measures like the business that you have brought in, the hours that you have put in, the successes that you have accumulated, the professional recognition that you have accomplished, the whatever it is, the appropriate criteria. I'm going to say the publications that you have made, but that may be an academic matter only. Let me make good on the first bullet point here, which is negotiation skill building. To help everyone listening to this CLE do better on that front, let me give you a very quick and dirty tour of basic negotiation skills by showing you a little bit about the stages of a negotiation so you can kind of understand what you're in while you're in it. Then I'm going to help you learn how to prepare for negotiation. As I said earlier, that is the most important thing you can do. So I'm going to give you a quick and dirty training on that. And then I'll conclude this piece with a word about how to assess the kind of negotiating situation you are in so that you know what kind of strategy to use in application to that negotiation. But first, the 6 stages of a negotiation. Every negotiation, more or less, is going to have these 6 stages in some order, probably roughly something like this, but it could be different. But these stages include, number 1, the most easily missed, the one that you will never miss, because I'm going to show you how to do it, preparation. You prepare for the negotiation. You go in armed with some research and some clarity on what you want. Then there'll be a period of rapport building when you establish the relationship within which you're going to negotiate. And it may be a long-term relationship. It may be a relationship that lasts much longer than this initial negotiation, an employment relationship, a business partnership. And it may just be a one-time transaction to buy a house or something. But even in that one-time transaction, you still have to build a relationship in which to negotiate. And that relationship will have a lot to do with how the negotiation goes. At the same time as rapport building, maybe afterwards, there will be some information exchange where you learn a little bit about what they're looking for. You share a little bit about what you are looking for. And then you begin to generate some options, some possible proposals by which you might come to an agreement. We call this the integrative stage of the negotiation. It's the stage where if it's a complex negotiation, you can widen the pie, maybe get more value into that pie so that when you then carve up the pie, there's more to be spread around. And that happens in the distributive stage where you do divide the pie. Everybody figures out what they're going to get. And you come to an agreement. And then the final stage, which is extremely important for lawyers, is the commitment stage. And this is where you formalize the agreement you've made in a way that will be enforceable. So it draws on a lot of lawyering skills of contract law, writing, drafting, and other measures that can create enforceability to the agreement. Now, that's what's going to happen in the negotiation. But before you show up at the table, here are some things you should give thought to. And I actually have my students write this out in a prep memo. And even I do a prep memo when I have an important negotiation, just to emphasize how important these pieces are to have thought about before you show up. You will want to clarify the issue. If it's a salary and employment negotiation, that's pretty clear. You'll set your target and your reservation points, the target being that high expectation you're aiming for, the reservation point being your bottom line. And as we discussed earlier, you want to aim for your target, aim high. Don't just play it safe. You will end up close to your bottom line. You want to identify the interests on both sides of the table. And by interests, I mean not the goal, not the target, the thing you want, but the reason why you want it. So if your target is a high salary, why do you want that high salary? Is it because you have educational debt that you want to extinguish? Is it because you want to buy a house? Is it because you need to take care of your children or your parents, or you have some other financial obligation that only can be met with money? Think also about their interests. What is it that they are looking for? And especially be paying attention to the things, the interests of theirs that you will help meet. That helps you understand, for example, your leverage going into the negotiation in this case, positive leverage, something you bring to the table that they want. So the next part of the preparation is to evaluate your BATNA and your leverage. BATNA is a piece of negotiation jargon that stands for the best alternative to a negotiation agreement, best alternative to a negotiated agreement. And it basically means, what are you both going to do if you don't come to an agreement? If you don't take this job, what are you going to do instead? Do you have another job lined up? Does it have a good salary? What is it? These are all going to help you understand maybe what your target and reservation point should be in this negotiation. What is their BATNA? Is this the kind of position that requires a real specialty skill for which it's hard to find someone to do it? That gives you more leverage. You want to think about the leverage. They have the leverage you have. You want to generate the potential proposals that might become the basis of an agreement. You want to consider the opening offer that you might make and that they might make. As we've discussed, you want to prepare to justify your positions with authoritative norms, objective criteria. So you want to think about what those are. Know the industry standards. Think about principled arguments that support your ask, especially on the basis of principles that they will share, whether it's fairness, combating gender bias, or whatever that principle might be. You should develop an information management strategy, which is just a fancy way of saying, give some thought to the information you definitely want to give to them. What is it that you want them to know? Something about how awesome you are, maybe your awesome BATNA. What is it that you want to get from them? What information do you want to ask that you couldn't find out on your own that will really help you understand what is a good or a bad agreement for you to make? And you might give some thought to whether there's any information you don't want to share, information you want to guard, and be prepared with what you might do if confronted with that question. And finally, and I'll conclude this little negotiating lesson on this point, you want to give some thought to the situation and that you are negotiating in and the strategy that it calls for. And here I'm drawing from a piece of wisdom in Richard Schell's Bargaining for Advantage book. And he invites us all to seriously evaluate the context that we're negotiating in order to know which tools to really deploy at the table. Because there are different kinds of negotiations you might find yourself in. Are you negotiating in a one-time transaction to buy a house where there's no relationship after the deal is done? Or is this an ongoing relationship that you're negotiating in the midst of a business partnership, a family relationship, where the relationship matters quite a lot? Or is this a balanced concern scenario in which both the stakes of the deal, which is all that matters in a transaction, and the ongoing relationship that matters very much in a relationship negotiation, if both the stakes and the relationship matter, like in an employment context, you're in a balanced concern scenario. So the conventional advice is, in a transaction, you want to prepare to negotiate fairly competitively, or at least be prepared to negotiate competitively, because you have to prepare for the possibility, perhaps the likely possibility, that the other party is not really looking out for your interests. They are primarily looking out for their interests because they're not protecting the relationship because there is no future relationship to be had. That's not going to describe every negotiator in a transaction, but it's something you want to be prepared for. In a relationship negotiation, you want to prepare to accommodate. This is a scenario in which protecting the relationship is probably more important than whatever the stakes are, a marriage being the paradigmatic example. Whatever you're negotiating about, the marriage itself is more important than the stakes. But in a balanced concern scenario like an employment negotiation, you want to prepare to collaborate. And that is the fancy negotiation theory word for when you are going to press hard on both the stakes and protecting the relationship. Perhaps by looking out for the interests on both sides. You want to press your interests and make sure that they are met, but you might be able to use some of the interest-based bargaining skills that Richard Schell is teaching, that I like to teach, that the Harvard Program on Negotiation likes to teach, to grow the pie, to enable an outcome that really does meet both sides' interests. You want to meet your own interests, but you also want to have a productive, ongoing relationship with the other side. So making the deal as protective of both of those things as possible requires collaboration. You're not just accommodating, you're not just competing, you're working together to try to make the situation better for everyone. Now, the very last, my last slide, the point I will close on, there are some thoughts, some reflections about how we can move forward in the face of gender bias, not just individually, but as a profession. Because that's what we are, that's what we do. And we see data that gender bias and especially gender pay gaps in the legal field are as intense as they are anywhere. So here are some things that as we become leaders in our organization, we can also do to try to not just navigate around gender bias, but push back against and ultimately eliminate gender bias. The first thing we can do is increase objectivity. Again, it's a theme of my presentation. Institute salary benchmarks based on objective criteria. That removes the impact of gender bias because we just look and see whether the person has met the targets. I won't say it removes gender bias, but at least it mutes it and mitigates it by attaching rewards like salary and recognition to observable objective criteria. Also, we should conscientiously avoid personality-based performance review. We should be on guard against it. When we see it, we should know, this is an indicia of gender bias. We should be careful about it. It doesn't mean that it's never appropriate, but it does mean that we always have to pay close attention and make sure that we are not engaging in or complicit in gender bias as it impacts our employees and our communities. We should increase transparency. We should make it easier to know what others in the organization are getting paid. Facilitating access to this information enables everyone, both the employer and the employee, to use objective measures. And some states have actually taken to a legislative solution to this problem by, if not requiring salary to be made public, preventing employers from asking for salary history. Since we know that women don't ask on the way in, they start at a disadvantage, and then when they move laterally, that disadvantage follows them every time they are required to give up their salary history. So increasing transparency that everybody knows what everyone else is making makes it easier for us to negotiate for gender equity in setting salaries. Maybe reducing transparency by preventing employers from asking for salary history helps mitigate the effects of gender bias in the past. We should facilitate professional networking, connecting junior women and all of our juniors to higher status mentors who can help them through the hurdles of gender bias. We should especially provide support for people bearing the double bind of childbearing during a professional career. We know that is the moment at which gender bias begins to most derail women's careers. And this is so obvious, I almost don't need to say it, but I will. We should be on guard all the time, scrutinizing for gender bias. Gender bias is like all implicit biases. It's omnipresent. We all suffer from it, whether we realize it or not. Eradication begins with awareness, and it ends with follow-through. So these are some thoughts about what we can do as leaders of the profession to help, not just help women over the hurdles, but try to remove those hurdles to begin with. So I'll close the same way I close when I talk to my students about this. My goal is to give all of you the information that you need to make a good assessment about how to behave in the world, some tools that you can use and that you can choose to use or not to use to help you navigate these hurdles in the world, but also the responsibility, the opportunity to make the world better by eliminating the need to use these tools. So let us be the changes that we want to see in the world when it comes to gender bias and all implicit bias. And with that, I will turn the presentation back to you, Maggie.
Well, Professor Ryan, that was a great and comprehensive presentation. Thank you so much for your time. Next up, we have Kimberly Sands. Kim is a partner and professional neutral at Upchurch, Watson, White & Max, an alternative dispute resolution firm. She has experience in, and this is not an exhaustive list, commercial, business, insurance, labor and employment, professional liability, civil injury, and complex and multi-party disputes. She is a Florida Supreme Court circuit and appellate certified mediator since 2001 and has been negotiating on behalf of others since becoming a lawyer in 1983. Kim is a graduate of the University of Pennsylvania and received her JD at Rutgers University School of Law. Welcome, Kimberly Sands.
Thank you. And thank you for allowing me to participate in this bar presentation. It's a topic that's near and dear to my heart. I'm going to show you a little PowerPoint, and then, I welcome any questions that you might have that would make it more specific and more applicable, perhaps, to people's circumstances. Let me just tell you that from my background, I'm a certified mediator in Florida, and I've been negotiating, well, actually, since I started practicing in 1983, but certainly since I was certified in 2001. But I've always been interested in the subject of negotiation, just as I've always been aware of the fact that I'm negotiating in pink. I titled it this way for shock value, because no matter what you do, no matter what you say, the first thing that anybody sees in you is your gender. And there are some chips that come with that. There are some drawbacks that come with that. There are some things that you have to be aware of and you have to overcome in negotiation, particularly when you're negotiating for yourself. I have found that that my gender is a strength, not a weakness. And that I hope as we go through these slides, you will agree with me that it is perfectly appropriate to negotiate in pink, which means to be yourself, to remember what you are, to remember that everybody's first impression of you is that you are of a gender that carries certain preconceived notions with it, and that the best you're going to be able to do is recognize those preconceived notions and work to them as your strengths, not as your weaknesses. So moving forward, what do we know? And I know a lot of this was covered by Dr. Ryan, and certainly better than I, but as a layperson, this is what we know. Women are less likely to negotiate their salaries. Why is that? Well, first, they undervalue their worth, and they do that across the board. But also, there's a penalty of being assertive, and that's real. That's not in your head. That when men negotiate salaries, they're seen as being competent and assertive, and it's a plus. When women do it, you're seen as being uncooperative and more trouble than you're worth, probably. Also, what do we know? Women are more likely to be lied to by men and by women. They can be little lies and they can be big lies. They're the type of lies that we tell each other in negotiation. Women are more likely to be subject to that than men are. We need to just be conscious that statements that are made may be misleading or may be outright untrue. Men and women give preferential treatment to men. That's probably no surprise. There's a sociological phenomenon of the token whatever. And you figure once you got one, once we've hired a woman, well, we're diverse. And there's no more seats at the table for another woman. That is not intentional. It's not conscious, but it very much exists. And men and women are also more likely to share otherwise hidden interests with men than they are with women. And why is this important? Because the most significant part of negotiation is understanding the needs and wants of the opposing party and being able to convince them that what you are negotiating, what you are proposing, serves those needs. So what's the remedy to these weaknesses, these downsides that we have with respect to negotiating for ourselves? The first recommendation is to be non-threatening, to be a woman. Smiles, friendly gestures, traditional behavior. By this, I do not mean resorting to flirting, but if you've got it, use it. By this, I mean traditional roles: mother, sister, aunt, friendly teacher. These days, women could be the one everybody wants in their study group, or the one everybody wants to be working on their project, because those strengths that women have are recognized, whereas the more traditionally associated with manly attitudes like aggressiveness and assertiveness don't go over so well. So be yourself. Consider yourself in relationship to something that has a positive association with the person that you're negotiating with. Frame requests as a benefit for the organization. There are various modes of negotiating, but the one that works best in these types of salary negotiations is collaboration. Tell me what you want, and I'll tell you what I can do for you. Tell me what your needs are, and I'll tell you how I fulfill those needs, and how fulfilling the needs that I have in relationship to the organization will better this organization. The traditional arguments that are based on competition, where you're putting yourself up against whoever else is applying for the job, or where you are putting yourself in a position of saying it's me against you. We're both trying to get the best and the most we can out of this, and that there will be a winner. That works for guys. It does not work for women. It's, again, that double standard in which it's interpreted negatively. And that interpretation can be carried through with your entire association with the organization. Preparation. This is the most important thing in any negotiation for any reason, is to be prepared. Most important thing is to know your worth. Don't focus on your weaknesses. Focus on your strengths. You probably have more of your strengths than you have any weaknesses for any job that you'll be applying for. The research suggests that men will apply for positions that they're about 50% qualified for. Women apply for positions only if they're 100% qualified. And that does not mean that those guys don't get that job. They do. But it's because they sell themselves. They focus on their strengths. They misrepresent themselves, puffery, not in a fraudulent way, but they overrepresent their abilities. Women need to get comfortable with what their strengths are, and they need to recognize it, and they need to sell them. So know what your worth is. Knowing your relative worth is knowing what your worth is in the market. Are there 100 people who have applied for this job, and they've got another 50 that they could go to if we can't agree on terms? That's going to make it more difficult for you to negotiate than if you were the pick and they want to put all their eggs in your basket, and now we have to reach terms. So understand the competition, understand what your relative worth is in the market and within the group of people who are applying for a position or are going to apply for similar benefits that you're requesting. In negotiation, we talk about knowing your BANTA. Again, most important thing in negotiation. What is your better alternative to a negotiated agreement? Do you have a better alternative to a negotiated agreement? When we negotiate in litigation, we ask ourselves, do I have a better alternative in litigation than this settlement agreement? If I don't, I need to look seriously at the terms that I am negotiating and negotiating the best deal I can, because I do not have a better alternative to a negotiated agreement. In applying for or negotiating a job, your better alternative is I can go someplace else. There are other organizations that better suit my needs, that are more interested in me or willing to give me what I want, are closer to me, have a better position, have a better prospect long term. When you're exploring your BANTA, explore everything about the nature of the job that you're in or the job that you're applying for, so that you do know what your options are. Knowing your options allows you to be a stronger negotiator. If you know the other side has fewer options than you do, if you know what their BANTA is, what their better alternative to a negotiated agreement is, then you know how far you can stick to your point. Because if they don't have a better alternative to negotiating with you, then you may have an upper hand in negotiating with them. So again, very important to understand what the needs are of the organization, how they think, how they're structured, how they pay people not only in salary, but how they might pay people in other things that might be equally important when you think about it. So if somebody's going to pick up my educational loans, that has value. What kind of value does that have in comparison to the additional money that I'm requesting? What kind of value does that have in the long term? What kind of value does that have towards my progression through this organization? Same thing with moving expenses, bonuses, things like that. You don't have to deal just with the salary. You can deal with other things that may, when you pull back and look at it, be just as important from either a monetary or a personal well-being point of view to you. Flexible hours, whatever it is, open your mind up to the possibilities of what might make this situation better for you and what your viable alternatives are under those circumstances. Very important, as I said, to know the interests of the other party. If it's a firm that specializes in a certain area or wants to break into a certain area, and you can offer them that strength, you can offer them the ability to build a practice in a certain area. if you've been in certain community or charitable groups such that you have contact with lots of people who are potential clients, that is a strength. That's something that if that organization is interested in making headway into that group, you can offer. So again, know what their interests are. Know not just what the salary schedules are, and as much as you can about what people are being paid in that community and in that organization, but also what they are looking for and what they value. Because if they value one thing that you have, that can translate into a monetary value as well. So in any negotiation, what do we have that they don't? I hate to put it that way, but we're the ones that have the chip on our shoulder, so we're the ones that have to address it. We have emotional intelligence. Those are positives: creativity, flexibility, able to think outside of the box, be integrative, be open, be willing to cooperate, to exude an aura of cooperation, and that everything you do is certainly for your betterment, but it's also for the betterment of the organization. In all of the literature involving this issue with respect to women, and actually with respect to lots of other practitioners, there's the question of being positive and being mindful. Pump yourself up by reading Lean In by Sheryl Sandberg. I mean, that's basically the treatise on what women are doing wrong and what they can do to make it right. And the same can be true for Getting to Yes by William Uray. That is a must-read book for anybody who negotiates. And anybody who reads knows that you come away from a book feeling whatever empowerment that book is going to give you. And you absorb whatever information that book is going to give you that's going to benefit you as you go forward. And these are two books that empower you as a woman, and they empower you as a negotiator. Very simple reads, very obvious things, but to just have somebody else say, yes, that's right, that's what you should do. That what's happening is accurate, and this is what you need to do to combat it. These books provide that. Negotiate to the win-win. In salary negotiations, you're in a unique position where you can look at it as a win-win. You're negotiating for the organization. The relationship should be what we can do together, not what I need, not what are my needs. Although those they have to be intertwined into the discussion, into the negotiation. But it all needs to be phrased in the point of what I have done for you, what I can do for you, what value I have to you, why I have become indispensable, because that's the ultimate goal, is to be indispensable, where you have the negotiating power and they don't. And so what can you do for them, and what benefits are they going to provide to you that are going to facilitate your being able to do that for them? We've talked about this. I'm sure others have as well. Consider the package. It's not just a salary negotiation. Men lead very linear lives, very singular lives. So this historically has not been as important to people in the workplace. It's important to women. It's increasingly important to men. It's considering your work-life balance. So go for a multi-issue approach. And that may be perceived as less threatening, less aggressive, more cooperative, collaborative, problem solving. You're displaying your depth because you're helping them problem solve while you're helping yourself. And they may be less resistance to the idea of picking up health insurance for the whole family, or a bonus on signing, or moving expenses, or anything that you can think of that's going to be meaningful from a trade point of view in your negotiations. Now, one thing you should keep in mind here is that the pay you go in with, it can be vitally important to your earning ability over time. And so if you go in with something that's less than satisfactory, the sooner you can correct that, the better. Because you can imagine if you're making $10,000 less than your male counterparts, you will continue to make $10,000 less, or that gap can get bigger and bigger and bigger as you progress in an organization and receive increases in pay and increases in position and are considered for bigger and better things. So it is important early on that you consider these issues of salary and satisfaction with the organization that you're in. And that's particularly true for law practice, but I assume it applies across the board for any industry. This may sound silly, but this is what all negotiators do. If you take the training for mediation, you role play. You practice the negotiation. You can do it in the mirror. You don't need to do it with somebody else. But it does help to have somebody else, to have a partner who plays the role of the interviewer or the partner that you're negotiating with, and that they role play with you, so that you get used to that back and forth. You get used to the conversation. You get used to making the points that you want to make. You feel more comfortable doing it because you've done it before. It sounds silly. I know it works. So negotiating on behalf of others, here's the good news. This is why I'm doing what I'm doing, and quite satisfactorily. Gender issues can be reversed. Women can be more effective negotiators than men. The things that make us women, all the things that I talked about before, all the things that are, seemingly built into it, certainly our socialization, if not our DNA, credibility, sincerity, empathy, verbal skills, being able to read and understand the needs of others, having others identify with us as somebody who wouldn't lie to them, who wouldn't cheat them, who would be more sympathetic to their circumstances and try to find a solution that's satisfactory to all. Those things can be used in negotiation. And as I said, your emotional intelligence, being able to read the other side, vitally important. Part of emotional intelligence, and one of the skills that you absolutely need in negotiation, is the ability to listen. Listen to what the other side has to say. You want to know what they want, and you want to know why they want it, so that if there's any way that you can serve those needs while also serving your own, you can weave the negotiation in that direction. Parties ask for things, and they don't necessarily think about why, and they don't think about how they're going to get there, because it's a two-party or multiple-party system where they have to have negotiations, and they're not sure what's going to happen on the other side. If you can listen to what those needs are and serve up empathy and understanding, but a means of achieving those ends while also achieving your own, you'll be more successful in negotiation. Preparation, the same thing. You got to know your case. And I'll stick with legal issues because it's the bar. And women, I got to say, in the years that I have been negotiating are some of the best at this. They know their case. They're so used to being faster, stronger, putting more work in, trying harder, trying to hit that 100% rather than that 50%. That preparation is basically built in by the time you become a member of the Florida Bar as a woman. It's vitally important because you want to know your case inside and out. You want to be able to respond to anything that they may say that's negative. You want to be able to respond with what's the strength of your case, not the weakness of your case, how you can undermine weakness. But you also need to know your banter. You need to know what your better alternative to a negotiated agreement is, so that you know when I need to get out, when I've gotten enough, and the rest is going to be not a better alternative to this agreement. If there is a better alternative to the agreement, then you're not there yet. But if there isn't, then you know the limits of what your negotiating powers are going to be. If you know the other side's banter, if you know what their better alternative is to a negotiated agreement, again, and if they don't have one, then you can play on that weakness. But you need to look at it from the point of view of what the true interest is, not just what the want is, but what the interest is that's serving that want. So skills, we've talked about this, the credibility, the sincerity, all of the things that work for us when we negotiate for ourselves, they work like gangbusters when we're negotiating for somebody else, because we don't have the same drawbacks as women, internally or externally. We know our worth. We work with our worth. And we have these added skills and these added perceptions of us that benefit us when we're negotiating for others, and benefit us when we're negotiating for ourselves. If you recognize, I can negotiate in pink, I can be a woman, and I can negotiate in pink. And once I get past that first impression, once I get past that association, and you may have to get past it over and over and over again, once I establish myself, once I establish my worth, then I don't have the same hang-ups negotiating for myself going forward. You got to pump yourself up for this. And so all the methods and skills I've described come naturally to women. Value yourself, value what you are, which includes all the attributes you have as a woman, and to the extent they differ from the attributes that men have, it's all great. It's all positive. So value yourself without the constraints of others' implicit bias. There will be implicit bias. You are looked at differently, but recognizing what you need to do to overcome that does level the playing field. So what are the proactive measures? I hate to do this presentation and not mention that it's unfair that we have to adjust for the rest of the world. It's unfair that we have to try so much harder just to be recognized and heard. But I don't propose to change the world other than one step at a time, and one person at a time. So know your strengths and work your strengths. Be who you are. Be assertive, yes, but do it in the cloth of pink. Be assertive as a woman, and with all womanly traits. You still have to be stronger, faster, smarter, and work harder than everybody else. But you also still have to seek a work-life balance, and there's nothing wrong with that. If you want to be the best of the best of the best, that's going to be pretty hard without giving up something else. So pick what's important to you, what's going to make you happy as a human being, and make sure you find that work-life balance. And part of that can be in the negotiation you have with your employer about what will help you to find that balance. Absolutely vital that you find a mentor within your organization, within or without, but ideally within. Find a mentor who's going to build you up, who's going to give you advice, who's going to give you the benefit of their experience. Within an organization, a mentor can do a lot to promote you. And as you're being elevated, you need to educate and mentor others about what is possible. One of the reasons why there's only one seat at the table is because sometimes women are our worst enemies. Sometimes a woman who has made it feels threatened by anybody who's coming up because their perception has been, from whatever experience they have had, that there's only so many seats at the table, and another woman needs somehow that they are being displaced. You cannot think like that. You must think collaboratively. You must think in terms of this can't change until we all rise. A rising tide raises all ships. That's how you have to think. So you educate and you mentor others, and you open your arms to women who are coming up, and you help them with what you know and what you can do to assist them to make this a more diverse world for everybody. And finally, most important thing, in any endeavor you have, in anything you are attempting to do professionally, be professional, be ethical, and be yourself. That's the best way to excel and exceed all of your expectations. If you just work on those strengths in the context of ethics, profession, and who you are. And I'll give you a link to one of my favorite negotiating videos. I don't know if we're going to incorporate it in here, but I'll talk to Maggie about that. Whenever I do a presentation, I always like to give a video that's an example In negotiation, I usually default to clips from movies because you can't give somebody a role play and it's a role play. That's what it is. You can't make any one situation be applicable to all situations. There's no shortcut to the preparation. There's no shortcut to preparing yourself. There's no shortcut to getting the information necessary in order to be effective negotiating. That's all work that you have to do yourself. So anything that you see that is somebody negotiating is going to be a good example of, see, it can be done. And in this particular clip from the movie True Grit with Jeff Bridges, and Hallie Steinfeld is a great example of a 12-year-old girl going in and negotiating with a hardcore negotiator. And it's fun. So there's your link. Take a look at it. That is the best example of knowing your bantam that I've come across ever. She knows exactly what her alternative is, which is apparently she's going to file suit on behalf of the widow and children. And this guy doesn't want that to happen. So that's her ace in the hole. And her understanding of the value of what she's bartering for and what she needs to get out of the negotiation. What we don't see is that she needs a certain amount of money to pay Rooster Cogburn to go after the murder of her father. And she gets it. And enough money to stay in a boarding house for a night. So, and she comes back the next day and negotiates for the saddle and a horse. So it's pretty cute. But yeah, that's a great example of knowing your case and knowing what your alternatives are and knowing what the weaknesses are of the person you're negotiating with. That's why I include it. Banta is sometimes something difficult for people to grasp. Single most important thing in negotiation. Knowing what yours is, knowing what the other party's is. You know how far you can push it that way.
Thank you, Kim. So it seems to me that the remedy that you propose, and that one that is routinely proposed to women, is itself very gendered, isn't it?
No, it's very gendered. You're not wrong. But why in the world would you want to abdicate your strengths? Because it's the other party's weakness. So my dad said to me once, my dad was a lawyer. He's since passed. He was of an old school. Says to me in later life, I think women lawyers use their femininity to get ahead. And I said, well, gosh, Dad, what do you use? We all use what we consider our strengths are in relationship to the person or party that we're attempting to persuade. If somebody's so weak-kneed that they can be persuaded by a pretty face, why the hell not? Now, some of us don't have a pretty face, so we have to resort to other things. But that's why I say the association is not necessarily one of a man to a woman. It's a one of transference to a sister, a mother, an aunt, someone whom, you are inclined to look at as trustworthy and persuasive. But it is absolutely recognizing that there are differences between the sexes and recognizing that those differences don't have to be weaknesses, that they can be strengths, and that men can actually acquire, and many men do have, these same attributes. It's just less likely to be used, less likely to be necessary to use it, and so they don't develop those skills. But as I said, I don't propose to change the world overnight. I wish it was different. I wish I didn't have to work so hard at being myself and something else at the same time. But that's the best advice I can give right now to somebody who's trying to level the playing field.
In your experience, do men and women have different negotiating styles?
Yeah. Yes. There's actually, let me see if I wrote them down because I get them wrong all the time. Yeah, collaborative, competitive, accommodating, compromising, and avoiding. Those are the three different styles that people talk about in terms of negotiation. Women obviously default to collaborating, and men default to competitive. There are other options here, but in the circumstances of what we do, you don't avoid it. I mean, I guess there's some people who do, but that would be a very bad mechanism on behalf of your client to avoid negotiation. Compromise, you hear people talk about compromise all the time. To be honest with you, I don't see compromises that people don't want to make. Is that a compromise? If they are making a decision that they want to make because now they understand what the risks are, now they understand what the bad is, then is that a true compromise? Or are the parties reaching an agreement on something that they can both live with? So I don't consider compromise to be part of what I do. Although obviously compromise occurs because at some point somebody looks at the other person's position and says, well, if I want what I want, then I'm going to have to give them that. So compromise can come into the process regardless of which, I'm probably telling you more than you want to know, regardless of which method you start out with. I think the best negotiators are flexible and you move in and out of different modes depending upon what's required. But the default mode for women is going to be collaborative and accommodating. And there's nothing wrong with that. It works. But you need to be conscious when you're negotiating of your banta, of what you're giving up and what you could have.
One of the fundamental pieces of advice that you give is to know your worth. Can you tell me, practically speaking, what does that mean?
It's probably the hardest thing we do as women. What is my worth as an employee? What can I sell myself as? And women have a hard time doing that. Women have a hard time singing their own praises. Men have no problem with it whatsoever. We go back to the man will apply for a job he's only 50% qualified for. A woman has to be 100% qualified. But you have to get past that. You have to get past that and recognize, no, wait a second. I'm really good at this. And I've got these credentials and I've got these recommendations and I know what I'm capable of. So I'm not going to devalue myself in relationship to anybody else. Somebody else may end up doing that to me. But unless you build yourself up to sell yourself, why should anybody want to buy that? So you have to get over that thing that's built into us that makes us say we have to be 100% qualified, or we're not qualified at all. It's just not true. Whatever you've got going for you, whatever's good for you is enough, or is going to be enough. You just need to use it.
I could be wrong about this, but in the typical negotiation scenario that most of us attorneys are used to, so for example, an adversarial one where we negotiate on behalf of our clients, both sides are represented by hopefully competent counsel and they have both agreed to come to the table. The interests of both parties are relatively equal, which doesn't seem to be necessarily the case in employment negotiations because the person asking for a raise or for a better initial offer is probably in the weaker position.
Could be, yeah.
So what is the most important piece of advice you can give to level that playing field in employment negotiations?
If you've applied for a job and there's 100 other applicants that they're looking at, you certainly don't want to bring up anything other than, how you're good for the job. You don't get into negotiations. You might ask questions that give you the information necessary for negotiations at a later point, but you don't want to alienate anybody. And then once you've got the job, you have to ask yourself, how committed are they to me at this point? Or are there 6 other names right behind me that they're going to go make this offer to? So that's why you want to be fluid in the negotiations. You don't want to have anything absolute. I need to have this number or I can't come, unless that's true. But what you need to do is say, well, I'm looking for this, and I'd like to have a conversation with you about what your needs are and how we can make this work. And that's how you go about it, very collaboratively. And so once that conversation is taking place, they're now seeing you as a dynamic individual, not as just somebody they're putting a number on the top of your head about will they take this salary number or not. They're seeing you at work. They're seeing you dynamically. And they're going to continue to make further comparisons between you and whoever you're competing against for the number or the job and decide is that worth it or not? And the longer you keep the conversation going, the more you get to understand what their needs are and how you can fulfill their needs. But what you've got to be able to do is to be able to switch back to what are my needs? Where do I need to draw the line? And what things can I substitute in to see if this will work just as well for them as that? So we can agree on a number, but I've got additional benefits that make this worthwhile to me. It's a conversation. And while you're having that conversation, you are demonstrating all of your skills, hopefully. I mean, that's the goal. Does it work every time? No, but that's what you want to show is you want to show your depth, your flexibility, your verbal skills, your intelligence. That's what you want to show. And if you're already in the job and they know you and you're going in and asking for more money, so let's say you don't want to rock the boat on an entry-level position, you go in, you set the stage for another conversation. I'd really like to, I'll take it, but, I really want to have some conversation at the end of the year about where this is going and to revisit this issue. And then they have the year to look at it. But you need to consider that time frame in relationship to your value in the market. You need to get out early. You can't stay there for 10 years and have the same kind of value. You're going to have a lateral value at that point in time. These things build from the beginning. So you have to think about it from the point of view of maybe I'm going to give up something now, but I'm going to keep the door open so that we can revisit this conversation when they know more about me and I know more about them.
Anything to sum up?
No, I just hope that the information I've offered is going to be helpful, that it causes everybody who hears it to think about their circumstances and make a change for the better. And when we all make changes for the better, that's when things change for all of us.
Thank you so much, Kimberly Sands. Our final presenter is Tiffany Henson. Tiffany is Florida born and raised. She attended the University of Central Florida and then obtained her law degree in 2008. She started her career as an assistant public defender in Orlando before moving into private practice. In 2017, Tiffany made a bold career change and accepted a role as an attorney recruiter with Parker & Lynch Legal. She now uses her accumulated knowledge to assist attorneys, law firms, and corporations with their job search, including salary negotiations. She's here to share with you what she sees on a day-to-day basis, along with some tips and ideas when negotiating. Welcome, Tiffany Henson.
Hello, thank you. I'm thrilled to be here today to talk about this with you all. And we've already heard from some really great ladies with some excellent presentations. So I'm just going to jump right into it. I'm going to focus on things that I see on a day-to-day basis as a recruiter, and also offer some suggestions and tips when you are actually negotiating. So I want to start with just reminding you that all negotiations are situational. They're not all going to be the same. So everything that I'm going to be talking about is really generalized, and you will need to tailor it to your specific situation. I'll also say, because it's important to mention, that you should conduct as much of the negotiations as possible in person or by phone rather than by email. I know with working remotely, it does tend to be easier and faster just to send off some emails, but it's just really important to remember that nothing beats an actual conversation with a live person. Okay, so let's start with research, the most important. You can start your research online. You can check out sites like Glassdoor, Indeed, PayScale, Simply Hired. My company, Parker & Lynch, publishes a salary guide, which is also a great resource. So you really want to start with as much information as possible before you get into the negotiations. So some of that is pretty easy to find online. Some companies might not be that easy to find. You can also leverage your network. Who do you know that works in a similar practice area? Who works at the company or the firm? Who works in the same location? Because compensation is going to depend on where you are geographically, as well as the size of the company that you're in. So the more intel you can gather by using your network, the better. So next, let's talk about, do you have any leverage? What I mean by that, are you able to tell how many people have applied for the position? Are you able to tell how many people have interviewed for the position? How long have they been looking for someone to fill this role? And some of these questions come out during the interview process. So if you can find out, it's just going to help. Typically, the longer they've been looking, the more eager they may be to fill the role. And that could give you more leverage. I want to give that a caveat, though. You should err on the side of caution with that particular leverage. The firm's really always the seller, and they never have to actually buy from you. So you don't want to push that particular leverage too hard, but it's always good to know. Next to think about would be, is the compensation package even negotiable? You need to make sure that you understand the employer's limitations, because not all employers will have the flexibility to adjust base salary. And this might be a good reason why working with a recruiter could be a benefit. We usually have insider information that you might not be able to find out on your own. We could tell you the compensation range as well as any limitations for the position, and help you get creative if need be. But if there is no way to increase compensation because of the company's budget, you might be stuck and might be forced to get creative. And we will talk about some creative ideas a little bit later. You should find out as much detail as you can about the position. And I really mean beyond the general job description. To be honest, a lot of this you're probably going to find out in the interview process, because you're going to need to know what expectations you're going to have, what are your duties and responsibilities, all the things that you need to know to see if this is the right position for you. But you can also use some of that you learn as leverage on the back end when you are negotiating. What do I mean by that? So for example, if you find out that there's going to be some minor amount of travel, or maybe it's a lot of travel, you can negotiate a travel stipend or a car allowance. You don't want to assume that you're going to get that. I would hope that they would put that into the compensation package for you. But as we all know, you should never assume. You want it in writing. So make sure that you ask for it. Another example would be bar expenses. Are you going to be taking another bar exam for this position? Will they pay for not only the bar exam itself, which we all know is expensive, but your study materials? Will they be paying you time off so you can study? All those things are something to think about when you're negotiating. Okay, a fun one. How to value yourself. This question is not really about what you want or what you're currently making or what you've previously made. This one's really about what the employer wants to pay you. And this is why you really have to sell yourself. And this is something that happens throughout the entire interview process. You need to show them that you're worth every penny that you're going to be asking for. And they need to see that they need you. But what do you say if you're asked in an interview, what's your salary requirement? So this is a common question, and this one's tricky because you really don't want to get this one wrong. If you do, you can be locking yourself in to a number that's maybe below what they're willing to pay, and therefore you're leaving money on the table, which is not ideal. Or alternatively, you could be shooting yourself in the foot as over projecting a number that's way outside of their budget. Employers actually walk away from an otherwise ideal candidate because they didn't want to waste their time knowing that they couldn't afford this person. So I usually try to suggest to deflect this question if at all possible. And what I mean by that is, I know firm name has a reputation of being extremely fair when it comes to compensation. I'm really interested in finding the right opportunity for me in my career. So you're not really answering the question, but to be honest, it's not really fair for you to answer this question in the interview process. I understand that the employer wants to make sure that you're in their price point, but at the same time, you're still discovering details about the position. So how do you know what compensation is fair until you gather all the information about the role generally? So I just don't think that you should be throwing out a number during that interview stage. Really, the goal is to have the employer throw out the number first, in my opinion. That seems to work the best. However, some interviewers really push hard on this question. They really want to know a range. So you should be prepared with one just in case this comes up, because you don't want to be caught off guard and throw out a number that just doesn't make sense. So this is going to go back to bullet point number 1, research. I say throw out a number, but we're really going to give them a range. You don't want to just pigeonhole yourself into one number. So you want to think about what's the minimum number financially that you'll accept. This is going to be your bottom range, but you want to increase that just a little bit. You want to give yourself a little bit of a cushion. So that's the bottom range. Next, based on the research that you've done that we talked about, you want to pick a number that is maybe on the higher side or a little bit higher than you know that the firm will pay. So that way you're not really over projecting yourself too high. So they're so comfortable with the number that you threw out there, but you have a low end and a high end, and anything in that range is potentially negotiable. Okay. Another thing to think about is before you even enter into negotiations, what are your priorities? What is non-negotiable to you? What will make you say, no matter how good this job is, I'm not going to take this position unless X, Y, and Z. This is going to be personal to you. Sometimes it's strictly money. You need at least this amount of money to make this move make sense. Sometimes it's not only about the money. Sometimes it's about flexibility or hours or time off. This is something you need to reflect on so you know what your priorities are going into the negotiations. Another thing to consider, of course, is the entire deal, the entire compensation package. You don't always need to focus on what's the annual compensation. Of course, that's important, but there are a lot of other things to consider. Are they giving you a hiring bonus or a relocation bonus? Are they offering you flexible work environments, working from home? Are they, if you are in the office, is your commute time significantly less? Are they going to reimburse you for parking? Do they offer professional growth, tuition reimbursement if you're going to get your LLM? All of those things do translate to dollars in some way or form. So it's really just thinking about the whole package and what makes sense for you in your life. Kind of transitioning onto that about some ways to get creative about some of those things. If you find out that you're not getting anywhere on the negotiation side on base compensation, maybe because you're already at the ceiling for their budget, you can ask them if they would agree to increase your compensation after 6 months of employment. So they're getting the benefit of you working at that lower compensation, and you're getting the promise of in 6 months, you're going to get a salary increase. So that's worked before. What I've seen work probably more often than not is actually asking for a signing bonus. Even if you're not relocating, companies may not be able to increase compensation, but they can usually come up with even a few $1,000s for a signing bonus. And why would you want to leave that on the table if you can get that? If you're stressed out on everything monetarily, you can get creative with some non-monetary options. For example, if you're not satisfied with the compensation, maybe you can work a reduced hours schedule to make up for it. Or maybe you can have a lower billable hour requirement depending on your position. So those are just some thoughts. You can really just get creative and ask for anything that you can think of that makes sense for you. There's really nothing that's off the table. Okay, so creative benefits to transition from what we were just talking about. We've been seeing more and more benefits that are getting creative from firms and companies lately. So of course, the traditional health and 401k and all that is important. However, here are some hot items that we've seen, or ones that I just thought were very creative and unique, even some that are low cost to employers. So allowances for kind of daily lunches or kind of Grubhub deliveries if you're in the office or even at home, I suppose. Gym memberships, car allowances, we've already talked about that. Budgets for home offices. If you are in the office, I've seen allowances for chairs. So you can choose, your personal chair, the one that suits you the best. I just had a baby recently, so this one stuck out to me as a fantastic creative option. A breast milk shipping program. Milk Store will actually ship your breast milk, your frozen breast milk home when you're traveling for work. So I thought that was a unique perk if travel is something that's required. Sabbaticals, coaching, career developments, childcare, pet-friendly offices if you're in the office, traveling manicures. I thought this one was fun. Manicubes is what they're called, but they come to the office and will give you manicures. Office kegs, I've seen that. I've seen some really cool break rooms with some video games and arcade games. So that's kind of a fun environment. My favorite, though, is experience bonuses. And what I mean by that is companies will offer maybe $1,500, $2,500. It's a guaranteed bonus, and they want you to use it for some kind of life experience. So a typical example of this would be a vacation or travel. Obviously, that's not really on the radar right now. Hopefully it will come back soon. I know I missed that, but anything that would enrich your life, they're giving you money for it, which I just think is a cool reason to give you a bonus. However, my all-time favorite is a company I worked with offered a $1,000 bonus to any employee that took 5 days of paid time off in a row. And you don't really have to convince me hard to take off a week of vacation, but if you're going to give me $1,000 on top of that, I mean, that kind of makes me really think that you're a cool company. And it definitely made up for a lower base salary that company was able to offer. So sometimes looking at the creative options and benefits that employers have do make that base salary more appealing. So it's just really important to consider the entire package to see how it all stacks up. All right, so negotiation is hard work, and we all know that it can be difficult if you're not making progress, which is why I spent some time talking about creative options. I just really want to remind you that negotiation of your salary is still considered part of the interview process. The interview isn't over yet. Just because you guys have started talking numbers, it doesn't mean that everything is set in stone. The employer can pull the offer if negotiations go awry. So I just think it's important for you to remain calm, cool, collected, obviously keep it professional. I just think it's really important to remember that. And speaking of offers, if you receive a verbal offer, a lot of employers will call you and say, we'd like to offer you the position. Here's X amount of dollars. Do you accept? Try not to get too excited, even if you are excited and planning on accepting. You really want to, review the whole package before you kind of lock yourself into anything, even though it's verbal. You don't want to say yes, get everything in writing, and then realize, oh, I want to change all of this, and then go back to your potential employer and kind of say, yeah, just kidding. I want to negotiate all this. And it's possible. So it's just best to restrain yourself and say, I'm really excited. Let me review everything and I'll get back to you as soon as possible. You don't want to start off the relationship with someone you're going to be working with kind of going back on your word before you even start there. All right. So the worst professional regret, I think, is not landing that job that you really think could have changed your career, whether it's more balanced life or whether it's, more money. Don't let that happen. And the way you can do that is prepare. You really need to prepare your butt off for the interview because that's where it really starts. Without getting and nailing that interview, you can't really even get to the part on negotiating your salary. So I think that's really important to keep in mind that you should be preparing for the end game from the beginning. All right, I think that wraps up my presentation now, and I'll open it up to questions.
Thank you so much for that. Let me ask you, when we were putting together the idea for this CLE, I reached out to a lot of women attorneys to get their take on this issue and see what they wanted us to address. And a lot of them, interestingly, said, and this goes sort of to your point about research, was that in their experience, a lot of firms are really secretive about what they pay, not only to specific employees, but also to levels of employees. And some firms even go so far as making talking about your salary once you're in the firm a potential disciplinary issue. So how does someone who really doesn't know the inner workings of a given firm, how do they go about finding out what their negotiation starting point should be?
Yeah, it is hard if you're starting from zero, I suppose. If you can't find anything online and you really don't have a network that makes sense to really kind of pool information from, a recruiter, even if you just call them for a casual conversation, you're not working with them. I mean, we work with these firms all the time. So while it might be a black box and they don't want to, share compensation, we usually know a thing or two just because we've worked with them or we've talked to people that have worked there and we have our nose to the ground. Also, the salary guide I mentioned, we kind of pool. It's an anonymous survey that we take across the state, and we ask people to kind of let us know what they're making. And it's gauged on firm size. So that's helpful at least to know, okay, I'm in Orlando and I'm at a mid-sized firm. This is kind of the average for this area. So it's at least gets you started for a range. But yeah, every firm could be different.
Going to one of your earlier slides, I'm wondering what you think about if somebody really doesn't know. Do you think it's a good idea or a bad idea for them to think about their estimate on what they want to get paid based solely on their own priorities? Is that a good way to approach this?
Yeah, I mean, ideally, hopefully you won't have to commit to that range. That would be the ideal situation. So that way you are waiting until the employer throws a number at you, and then you can see where you're starting from. So if you were way off, you're like, okay, now I need to tailor it down. There are some employers that do kind of push for that answer in an interview. More often than not, they're okay if you deflect, kind of like I was, that example of that talk track, they're okay with that. But depending on the personality of who you're interviewing with, sometimes they push a little harder. So hopefully you won't have to come up with a range, but I always think it's helpful to be prepared for one in case you do get pushed, because you want to have your numbers ready to go so you're not locking yourself in.
So on that topic, is there any benefit whatsoever to over-countering a salary offer, assuming you'll probably just end up in the middle?
Yeah, I mean, that's definitely a good tactic. You want to leave yourself room, so whatever you're going to be happy with accepting, you want to kind of over project that a little bit. The trick is not shooting so far over that they just, shake their heads and just like, well, we're not going to agree, and then kind of cut it off, because then you have to, wait, and then kind of like crawl back to them. And then that's obviously not an ideal situation. So you have to kind of use your judgment based on who you're talking to and how it's going. I mean, some employers are pretty open, like this is, the max we can go, and that's that. And, I find that refreshing when people are just completely honest and, this is what we can pay you. I can't go any higher. But yeah, there's no harm in shooting a little bit higher. So that way you are landing in your comfort zone.
Let me ask you this. You're an attorney, but your primary work now is as a recruiter. In your experience, is there a difference between how women negotiate for other people versus how they negotiate for themselves?
Yeah, it's funny because I was listening to some of these other presentations and I was really hit by that is, when I'm negotiating for, an attorney that I'm working with, I just don't think twice about it. But when I reflect back on my own career, I was more uncomfortable lobbying for myself. So I do think that there is something to that. And I think awareness is a step in the right direction, because I don't even think I was aware that I did that. And that now that I see and I talk with attorneys, and, I talked with an attorney towards the end of last year, and she received an offer and she was like, I'm happy with that. But I also hear that women never negotiate. So I just want to negotiate. I want to see what we can do. And I was like, okay, great. Let's do it. And, we were at that cap, the firm was at their budget, but we got her a signing bonus just because we asked. So, I mean, I think awareness is helping, and I'm noticing it.
Do you think it's a good strategy to tell someone who is about to negotiate for herself to pretend that she's negotiating for someone else?
I think that's worked for me, because I see myself when I'm negotiating, like I just said, for other female attorneys. And, I'm just like, this is what she deserves and this is why she deserves it. And it's kind of like, why shouldn't you do that for yourself?
What is your primary tip for someone negotiating for herself based on your experience negotiating for other people?
Yeah, I mean, sometimes if that's the way you need to look at it, now that I've self-reflected, I negotiate a lot better for the attorneys that I'm working with than I have done for myself in the past. So if you need to think about, I'm not negotiating for myself, I'm negotiating for, the imaginary person, do that. Or if you need a real person, I'm negotiating for my family. It's not just about me. I deserve this for my family. I think that's an easy connection to make, and I think that could help.
Thank you so much, Tiffany. On behalf of the Henry Latimer Center for Professionalism and the Florida Bar Standing Committee on Professionalism, I'd like to thank you for attending today. On a personal note, I'd also like to thank the staff of the Latimer Center for doing all the hard work in putting this CLE together. Rebecca Bandy, Katie Young, Beth Kirkland, and Clay Shaw. And of course, to all of our wonderful presenters. We hope you've taken something from this presentation and in the future that you will ask.